Senator Hancock, I don't believe, will be joining us. Ms. Brownlee was arriving at about 1:30. Nadia is not going to be joining us. So I was promised a quorum so we can dole out a lot of cash, but we'll need to hold off on that. So why don't we go ahead and get started on the stuff that does not require a quorum, and then we'll establish a quorum when we have sufficient members to do so. Thank you.
Yeah, we can start on the minutes.
Thank you.
Excuse me.
Well, you
minutes
can't do that.
require a vote. I apologize. Let's start on the executive officer statement.
Oh, pardon? We don't have a quorum, so technically we haven't. And one announcement, we do want to start with the Bagley-Keene presentation by the Attorney General's office at 2:30. So just to kind of out of respect for their time that they're going to be coming in. So that's kind of the goal at this point. So I'm sorry. Ms. Silverman.
Yes, tab 3, executive officer statement. We have several things to share with you tonight. We're pretty busy over the last few months, and definitely a nice way to end off the year. We actually have an opportunity to provide millions of dollars in project apportionments today, and we're happy to announce that. So attached in your agenda in tab 11, we are presenting 377 projects worth $923.8 million in state funding. And this was all due to the state bond sale in October 19th of this year. And again, the goal is obviously to provide these apportionments to those projects on the unfunded list, creating thousands of jobs and stimulating the economy. So what's really critical tonight is those projects that are receiving apportionments today, please realize that you must submit your fund release authorizations and your certifications that you're going to have your project ready to go in 90 days. And that must be hand-delivered, physically received no later than the close of business on March 13th. And for those districts that do not meet the timeline in the certification, please realize that you'll be placed on the bottom of the unfunded list. So again, that's a real critical point. The next item I would like to share is going on the certification information that we received over the summer. We will be opening up a new round of certifications, and that's coming up in January. So again, alerting those folks who did not come in this time or even didn't get cash this time, please submit those certifications. That round opens up on January 11th, which is Wednesday, and that will be active until February 9th. So again, for those folks that didn't get awarded projects, please resubmit your certifications. And that will be good for 6 months. The third item we'd like to share is the Overcrowded Relief Grant. We are providing unfunded approvals for the 8th filing round, and that represents 17 projects for over $85 million. And that would actually replace 202 portables, which is great news for those folks in the community. And with that, that leaves $328 million of bond authority for future funding cycles. And the 9th funding cycle deadline is January 31st. The third item, fourth item I'd like to share is the Interactive Project Information Worksheet Database. Back in July, the board was advised that staff is developing some information or interactive tools that we wanted to provide to the public, and that information really provides a synopsis to the public, the project information worksheet data information that we've been collecting. That tool is actually online for OPSC's website and also available on the Governor's Bond Accountability website. And again, it just actually distills down the funding expenditure, the bond sources, and the types of facilities that are being built. And we also wanted to note that there are also some high-performance projects in the mix there as well. We also are having some proposed regulation change for the labor compliance program, and that's tucked away in tab 12. And again, the purpose of the regulation change was obviously we were planning to submit that on an emergency basis to the Office of Administrative Law. The proposed changes will implement XBX 29 and AB 436, which requires that Department of Industrial Relations directly provide prevailing wage monitoring services for all state public works projects. The only exceptions would be for the statute or for those districts that enforce a DIR-approved internal program or for those school districts that have their own qualified collective bargaining agreement. In addition to the DIR regulations, again, those regulations will become effective January 1st, 2012, and therefore all state-funded projects for which construction awarded on or after January 1st, 2012 will be subject to the new provisions of DIR regulations. Get your attention to the following page is we have two more items. I'm going to wrap this up soon. Upcoming new construction
On
funding.
the labor compliance piece, I just want to acknowledge the work that's done by a lot of folks on this. Bill, thank you. You guys at OPSE, folks at DAR, and also the Attorney General's office. Thank you, everybody, and of course the folks out in the audience who are also participating on this. I think this is a lot of push and pull, so thank you very much. Appreciate it.
Thanks. Staff appreciates that. We have an upcoming new construction funding subcommittee meeting, and actually that meeting is scheduled for Thursday, January 12, 2012. The location and the meeting time will be determined. And again, the goal is to have discussion on the new construction bond authority, what's left, and possible future funding. The next item is the update on the solar energy hearing. We had an informational hearing that we actually held on December 5th. The purpose of that hearing was to identify again, solar energy initiatives and energy efficiency opportunities for school districts. Collectively, we heard from school districts on some of the outcomes that they're actually experiencing and also the other sources of funding that's available. There was a number of different agencies and private sectors that actually presented information, which is really useful. And again, the goal was the hearing identified a great need for additional low-cost financing for schools and technical assistance in this energy arena. So again, we understand there's tough times, and most districts and even states have limited resources to try to work together and try to result in some long-term energy savings. So again, staff is actually happy to try to add some additional information on our website, work collectively with these other agencies, and have a future outreach event. And again, that actually archived meeting is on our website.
Thank you.
So moving on.
Okay. Well, that was your tab, Executive Officer. Before we do that, is there any comments from the public on anything? This is the ARC. Where's Walrath? This is when the beginning of the hearing. You can come forward. Anything? Go ahead. Open mic.
Of course. Thank you, Mr. Reyes. Would this be the time to talk about, just briefly, the...
Name for the record?
Of course. Jeremy Smith on behalf of the State Building and Construction Trades Council. I hope this is the time to talk about the Compliance Monitoring Unit, the issue that you mentioned a few minutes ago. Is this the right time for that?
It's public comment.
Great. I wanted to echo...
Well, we're not going to be taking action on anything. This is the public comment where people can... So you got 3 minutes to...
Right. Thank you. I just wanted to say a few words about the Compliance Monitoring Unit issue, AB 436. I want to echo your thanks to the staff and the many people in the audience that have spent a lot of time working on this issue over the last several months. We wanted to make sure that the OPSC regulations clearly highlight the options given to school districts under the CMU. One option given to them is a project labor agreement. The language included in the description of that issue in this packet, we believe, is a little unclear in the sense that it talks about. It doesn't use the vernacular of a project labor agreement. Okay. It talks about a collectively bargained agreement, which, we can talk all day about the differences between those two things. They're similar, but we want to make sure that school districts understand that it's a project labor agreement or a PLA that we're talking about in the language, and we want to make sure that's spelled out very clearly, and we would suggest using those words and that acronym in there so they know that when they see the words collectively bargained agreement, it means that as well. And further, we believe that because the PLA option gives school districts all the cover they need for being in compliance with labor code sections, that the benefits of the PLA should be maybe spelled out a bit more so that it's very clear that if they do a project labor agreement, they are going to be in compliance with the requirements of AB 436 moving forward. Because of the way school districts fund their projects, which may include front-loading the costs and then seeking reimbursement, we want to make sure that school districts know in the regulations that if they have a project labor agreement and they do front-load the money they're using to build something and then try and get some bond funds on the back end, that if they do have a project labor agreement, they will be covered just in case they didn't have a labor compliance program that was already approved. Okay. So with those comments, I'll end. I just wanted to, again, thank the staff at OPSC, this board, for helping us figure out how to implement AB 436 in the best possible way. Thanks.
Okay. Thank you. Before we move on to the next speaker, can we establish a quorum, please? Thank you, Ms. Brownlee.
Senator Lowenthal, Senator Hancock, Senator Renner, Assemblymember Brownlee, Assemblymember Buchanan, Assemblymember Hagman, Esteban Almanza, Kathleen Moore, Nadja Dabi, Pedro Reyes.
Present.
We have
okay.
a quorum.
Thank you. Okay, next speaker.
We can go back to tab 2 for a minute.
Now
sorry.
we go to still public quorum. We're going to have to do something about the public quorum because it's kind of odd to have people come in and make comments about things that we're going to be talking about later. But technically, it's a public comment time, so.
Is this appropriate? I also wanted to make a statement about labor compliance,
Okay.
compliance monitoring. My name is Jenny Hanna. I'm with the Kern County Superintendent of Schools. Good afternoon, members. I just wanted to say that I'm a county office with a depth of experience with labor compliance, and I understand that program very well. And I'm also grateful for a lot of the work that's been done in Implementation Committee about the CMU process and some of the big gaps that were discovered there in terms of how it will fold into the funding program and how school districts will make notification, those kinds of things that, obviously are very important to the process. So what I would like to request is that a revisit of how successful or the ongoing program, possibly in 3 months, with DIR coming back maybe to report to this board about how that folding together is working in terms of the program. I think it, is complicated, and it would be a good thing to do. So,
Thank you.
Mm-hmm.
We have one more person.
Thank you. Good afternoon. My name is Kathy Allen. I'm with San Juan Unified School District here in the Sacramento area. And I would like just to put out there for consideration at a future date the possibility of allowing school districts that do not currently have a project labor agreement in place or an in-house labor compliance program in place the opportunity to be able to establish one of those two programs to be able to participate in the new CMU program in a different manner. So I realize that's not in the regs right now, but I agree with Ms. Hanna that I think a relook or a review of this down the road would be appropriate, and it maybe at that time we could consider something like that.
Okay, thank you. Anybody else public comment? Here or none, we'll go ahead and move on then. Can we have approval of the minutes? It's been moved, second. All in favor? We need to take roll call? Or, without objection, everybody present voting aye. Thank you. All right. Then we go back to tab 4.
Consent.
Is that right, Ms. Silverman?
Yes.
Okay.
Tab 4 is actually the resolution.
We have the resolution for Mr. Savage.
Mr. Savage.
Been moved in second. Without objection, it will be deemed read. Congratulations, Mr. Savage. Okay.
Tab 5 is consent.
Tab 5 is consent, and if I may, we also, if it's okay with the rest of the board, we would like to include tabs 13 through 16 in that approval. These are non-controversial items. They are action items. Any board member can pull any one of those, but they're pretty clear-cut. Mr. Hagman.
Mr. Chair, just on number 14, I just had some questions. I definitely approve of what we have in there, but of what we're going to do with the funds after we bring it back and how much. So I don't know if we could do that one separately, and I'll be happy to move on the balance.
We can pull 14 and have a conversation. That's fine.
Okay.
So 13, 15, and 16 included in the consent without objection? Okay, so that has there been moved? Is there a second? Second.
What about 17 and 18? You can read those off. Those are going to be part of it too, right?
Those are going to be part of the conversation. We're still going to discuss those, right?
Oh, okay.
So I'm sorry. In tab 18 is part of the consent. 17 we'll need to talk. 18 is also part of the consent. Okay? All right. Thank you. You need to take the roll call. Also, without objection, unanimous, so those present. All right. And keep the roll open because I know that Senator Lowenthal would like to come and vote on these items. Thank you. Okay.
Can I take an action?
Tab 6.
Tab 6 is our updates on the funds that we've been releasing on a monthly basis. And we've been reporting out to this board the amount of funds that have been dispersed. And so on page 185, we actually have a summation of the bonds that have been released in the April 2009 category. We released this month $3.3 million, and that's on the top of the page. And the middle category is the October and November 2009. We released $1.1 million. And in the lower category is November and December 2009. We didn't release any funds in that particular category. On page 186, on the top of the page, March 2010, we actually did release in that category $40.6 million. In November 2010, in that particular bond category, $2.4 million in cash was released. And as a result, we actually added a new chart, which is we're not authorized to release cash just yet, but hopefully show some activity soon. We do reflect the money in that particular new bond category. So we want to highlight that. And actually for the month on page 187, we did release $47.4 million.
Okay.
On page 188, we have this nice bar graph that we've been displaying over the last 18 months. The bar graph did grow to reflect the new receipt of funds in that category. The new chart shows that we have over $1.1 million, $1 billion, in cash now infused to the program. And again, those projects will be allocated in 90 days. So we'll show some activity over the next few months. And we have established on page 189 what we've been tracking, those projects that had 18 months to perfect on time limit on fund releases. And we actually reported in October that we had nearly over $91 million, and this is on page 189. We did reflect in October that we had actually $91 million. The projects had to come in at the end of October. We actually did report that on page 107, there's projects that didn't come in for perfection, and so with that, there's about $47 million in projects that didn't come in, didn't move forward, so we will be providing those new cash amounts available for a future funding round. I mean, staff wanted to make sure that we waited for all the mail to come in order to create some kind of cutoff, and those fund releases did come in and some didn't come in. So again, that chart has dropped off, and next month we'll actually add a new chart for the new projects that have been apportioned. So you'll see a much taller line being reflected next month for the new projects.
Can I ask a favor for maybe the future too? Since we always look at this progressively, what's coming up in the next few months. And for the last year, I knew that we had this October, November time period where the bulk of the first longer period of enactments were coming to expire. So we come back to this board meeting, and all that data is now history.
That's right.
And I know it may be somewhere else in the hundreds of charts and figures we have, but it may be easy just to throw the last month or two on this chart to say, you know, our projection was like for December we have 14 million. You know, the next month when January comes out, we could have the December on there 14 million. All 14 went out, or 14 came back, or whatever the case may be. Just give a little history, you know, review, because we just keep looking forward, and then we can say, oh, we got more money coming in, or we don't have more money going out, that type of thing.
Yeah, we could certainly do that.
Thank you.
Ms. Moore has a question.
Yes, I just wanted to ask on the rescissions that we took action on in the consent calendar. There's about $48 million. Mm-hmm. Are you saying, Ms. Silverman, that that will be going out to projects that are on the list? This list that we are
the certification round.
The certification round,
I think
or what's the anticipation on that?
The certifications actually expire January 9th. That's certifications that we had opened over the summer. So with that, we would have to establish a new cert for those projects that come in for that next round of cash. So we have the $47 million that came in rescissions, and we can award projects once we receive new certs.
And the new certs are due by March?
The new certs open up. We are actually asking school districts, if you want to compete in the next funding round, to start submitting your certs after January 10th for the new round, and then we can provide cash to projects.
But that round ends in March.
It ends February 9th.
February.
Right.
Because I would think that we would want to be apportioning that or allocating that cash as soon as possible. And so our soonest point that we can allocate the rescinded cash that we have here and potentially the leftover that we'll be dealing with today is February or March? Do we know?
Yeah, it would be March.
It would be March.
Okay, thank you.
No other questions? We can move on to status of funds on tab 7.
Are there any comments from the public on any of the items we've covered so far? Okay, thank you. Before we go there, it's 2:25, but our guest from the Attorney General's office is here. So can we just go ahead and move forward with that, with the Beckley Keene training that Ms. Moore was kind enough to have identified him in the past at some presentation, and that it would be of interest and benefit to the board to get this training from the Attorney General's office. Okay. Okay. 0 action items.
The apportionment of all the,
Oh, okay.
there's the apportionment of the apportionment of the 928 million.
Isn't that we just did a consent? Well, you're right. No, tab 11. We need to do tab 11, don't we?
Yeah.
Okay, 1 second. We're going to go ahead and cover tab 11 real quick. I apologize. Yes. Let's go ahead and go out of order so that we make sure I apologize for that. Go ahead, Ms. Silverman.
Yes, tab 11 is it's kind of a nice thing to actually, we're presenting apportionments tonight, and we're excited about that. As I shared with you earlier, we're presenting $923.8 million in funding for those SFP projects that have been sitting on the unfunded list. And again, that represents 377 projects for 154 school districts. If I can direct your attention to actual page 230. On page 230 was a summary of the certifications that we received from school districts on the unfunded list, and that actually accounted for $1.3 billion in requests, and that represented over 495 school projects. And we also wanted to summarize that there is actually a carve-out out of the cash that we do receive for charter schools. And on the top of page 231, we wanted to break
Mr.
down...
Almanza, hold on.
I move for the staff recommendation approval.
Thanks.
Been moved in second. Does board members have any questions? Without object, any public comment? Yes. Go ahead. Juan, would you be kind enough to... Oh, there we go. All right.
Thank you, Mr. Chairman and members. Moira Top on behalf of the California Charter Schools Association. We are very supportive of this item. We appreciate the board's action in providing $41 million for charter school site and design. This is about $50 million shy of what the board's action was to allocate or identify future proceeds in prior board actions this summer. The board had acted, as you remember, to provide $90 million in future bond proceeds, and we do recognize that that for whatever reason this is shy of that $90 million. But we would ask that as we move forward, since we don't know when the next bond sale really will be, that we work with you, with your staff over the coming months. Ms. Moore, as you mentioned, there is additional funds coming in. There might be a way to use those funds earlier if we can identify those and make up the difference, that $50 million difference with other funds. And so we would ask your indulgence in that and appreciate your action today.
Thank you. Mr. Hagman.
Thank you, Mr. Chair. And that was actually one of the reasons why I was holding up on number 14. I was going to make the same point. We do have a bond, so we don't know when the state's going to be positioned to do another one. This is going to give a lot of projects going, and I'm wondering if we can maybe ask our staff to see if we do get these rescissions back from last month, the 40 whatever, close to that million. It's almost making that program whole. I wouldn't quite get there yet, but if that would be acceptable for the board to kind of direct that back in that pot, can we do that? A, legally. B, is that something we could so direct?
certainly one of the options.
Because you don't have
with
to
the
go
resources that
recertification
come in.
process either.
Ms. Buchanan.
When we discussed this at the briefing, I think probably we're all in consensus that we made that commitment and we need to honor that commitment. And my understanding is part of it ties up even in terms of which bonds you can access for which types of projects. And so I think rather than giving you a specific directive, I would just suggest that you work with the Charter Schools Association. So as we move forward, whether it's through what we have now or the next bond sale, where you maybe work with the treasurer to make sure that we do all we can to live up to that commitment.
Because this has been been put off a couple times now, and this sense of parity here that we should be able to get there. Do you see anything out of this bond sale or the proceeds coming back? What's your sense? Is not committing you to it right now, but just from the numbers, what do you see that we could be doing?
Well, there are actually a few projects in December. If they don't come in at the end of the month, it is from a charter category, not related to a loan component, though. So we could check those funds. If the projects don't come in perfect, we'll look at the funds to see if it's the right source of funds. And again, in the spirit of seeing that's the right sort of cash for those next round of projects, we would definitely look into that.
And the ones that we rescinded this past month, the 40 plus?
That wasn't in the right category.
It wasn't in the right category.
Right. But we'll go through our funds and see if we can identify any other.
So let's ask staff to go back and look to see where we can come up with resources to provide for that commitment that the board has accepted. Okay?
We'd be happy to do that.
Okay. So the motion was moved and seconded. Without objection, it's unanimous from the board members present. And I don't hear objections, so yes. Congratulations on the $924 million and change. Thank you. Okay. Welcome. So, if for the record, if you introduce yourselves, please.
Hi, I'm Julia Villiver with the Office of the Attorney General.
And I'm Ted Prim from the Attorney General's office.
Thank you. Welcome, and we look forward to hearing, being educated on your issues. Bagley-Keene.
Okay. I'm going to start by doing a few things to try to set the Bagley-Keene Act in context. And I guess the first thing I'll say, which will probably surprise you, is that the Bagley-Keene Act is, in many ways, an inefficient and frustrating way to do business. And the requirements of the Act often make it difficult for people to communicate in their natural communication pattern, which is, as individuals, what we want to do is go and meet the other members of our body and find out what their interests are and work with them to develop a consensus. And we like to do that in kind of a private space so that everybody can be candid with one another. But if we understand the philosophy behind the Bagley-Keene Act, then I hope that some of these frustrations and inefficiencies will become clear in their origin, and that we'll understand that there's actually a reason with a higher public purpose to it for these things. So if you want to create a government organization that is built on efficiency, then what you want to do is have a department model style of government where you have a pyramid structure and a decision maker at the top. On the other hand, if you opt for a multi-member body as your form of government, then what you're opting for is a consensus building model instead of one that is built on efficiency. And in the consensus building model, we look for people of different backgrounds, different viewpoints, and different experiences to come together and develop a consensus decision. When the Bagley-Keene Act was adopted, there was another value choice that was made, and that was, while the body comes to its consensus, the public should also have a seat at the table and be a part of the consensus building process. Now, consensus building means that there's debate and deliberations and give and take. And all of these things take time. It's not an efficient process. And so when we do this, if we're going to create a place for the public, then things like public notice, testimony, and access to records are the kinds of things that then promote public participation in the process. And when we have closed meetings, or when we have serial communications amongst members that are out of the public site, then these things actually defeat public participation. So if you accept the premise for why we have multi-member bodies to develop consensus, and if you accept the premise that while we develop consensus, the public should have a seat at the table, then we hope that that accepting these premises will help you to embrace the process and to understand the fact that even though the Bagley-Keene may be inefficient, and even though it may be frustrating at times to have to do things in the artificial way that it requires, that there's a really good reason for that. And that reason is that we are able to do things openly and we are able to involve the public in the process. So we're going to come back and refer back to this philosophical framework as we go through the rest of our discussion today, and I'll now turn it over to Julia to make a few comments.
The Bagley-Keene open meeting requirements apply to state bodies. Well, what is a state body? Under the Bagley-Keene Act, there are 5 types of state bodies. Of course, the most recognizable state body is a board or commission that has been created by statute. For example, the State Allocation Board. State bodies also include bodies created by executive order of the governor. The Bagley-Keene Act, though, also applies to smaller bodies of state bodies, such as advisory bodies, subcommittees, task forces. These smaller bodies do not necessarily exercise any authority. They must have at least 3 persons, but the persons do not have to be members of the state body. They could be non-members as well. They can be either created by formal action of the state body or by a member of the state body. Formal action may take the form of express approval, either by vote or resolution, or it can be implied ratification after an advisory body has been created and is in existence. A state body can also take the form of a smaller delegated body of a state body, such as an executive committee that acts with authority on behalf of a board in between meetings. Delegated bodies must have at least 2 members. Therefore, when a state body delegates authority to 2 persons and each person has as much delegated authority as the other to act on the board's behalf, the 2 persons constitute a state body subject to open meeting requirements. Finally, a state body can include a public or private board or commission on which a member of a state body serves as a representative in his or her official capacity and receives funding from the state body. I will next address meetings generally. What is a meeting? A meeting, for purposes of the Bagley-Keene Act, is a gathering of a majority or a quorum of the members of the state body at the same time and place to hear, discuss, or deliberate upon any item that is within the subject matter jurisdiction of the state body. Your regulations provide that a quorum is 6 members. Often you take action at your board meetings, but a meeting can also occur when you're just receiving information, such as right now when you're receiving information from our office. Meetings can be held by teleconference. Teleconference meetings are subject to special requirements. They must be noticed as a teleconference meeting. The public must have access to all sites where there is a board member participating by teleconference. This means a board member could not participate in a teleconference from a car or from out of state. A member of the state body must be present at each site specified in the public notice. All votes at the teleconference meeting must be taken by roll call. There are exceptions to gatherings. There are exceptions for some types of gatherings at which a quorum is present. These are limited exceptions. These exceptions include social gatherings, informational conferences open to the public, open and notice meetings of other state bodies. These exceptions apply so long as the quorum of the members aren't discussing agency business. There's also an exception for open and noticed meetings of the standing committees of a state body, so long as the quorum only observe at these meetings. And I guess it's back to you.
Okay. So one of the more difficult aspects of meetings is what we call serial meetings. Not only does the Act cover the type of meeting we're in here today, where we all gather in one place and have a meeting that's noticed, but it also covers a series of communications, either directly or indirectly, by which a quorum of the body discusses or deliberates or takes action on a matter. And these can happen typically in either a chain or a wheel kind of format. The chain being that member A talks to member B, who talks to member C, who talks to member D, etc. Or a wheel, which would be member A talks to member B, then talks to member C, and A talks to C, and then A talks to D. Both of these kinds of situations are covered. Face-to-face, email communications, telephone calls, text messages, instant messaging, all these kinds of ways of communicating through social media. All of these things covered and constitute a violation if a quorum of the body is ultimately involved. And again, if we come back to the philosophy behind the Bagley-Keene Act, we understand that because of the fact that these kinds of communications ultimately deprive the public of their opportunity to participate fully in the process. It becomes more complicated when you introduce the fact of committees into the situation. We can look at this body and we can say that we have a serial meeting in violation when we have a quorum of the body involved. Once we put subcommittees into it that are smaller, then it becomes a improper meeting when we have a quorum of the subcommittee or committee involved. And so there's a lot to kind of keep your eye on to make sure that you don't stumble into a violation. Now, a lot of times a rule of thumb that's adopted by state council is to advise board members to stick to a rule of two. Basically, outside of meetings, talk to only one other person, and as long as you're not dealing with a three-person subcommittee, then you should be okay. That's not a legal rule. It's a rule of thumb that is used as a conservative means of trying to keep members from inadvertently getting involved in violations. So that's the basic test, is this less than a quorum concept of the body. Now, there is a specific exception out there also, which we refer to as the staff briefing exception. And that one is designed to make sure that your staff can provide you with information or answer basic questions in order to get you ready for a meeting. It's not to become a subterfuge for having a meeting in absentia. It's to get you prepared for the meeting. The limitations on that exception are two, and they're significant. The first is that the communications are separate conversations with the members of the body. So it's a one-on-one deal between staff and a member. And secondly, that there's not to be any cross-pollination between members, so the staff is not allowed to convey or reveal the comments of one member to any of the other members. So it's a way of trying to answer basic questions and provide basic information to get people ready for the meeting. It's not to be there as a way of building a consensus or getting the purposes of the meeting accomplished. So those are the basics of what is a meeting and the different kinds of agencies. So the next thing I'm going to turn to is the rights of the public because they are substantial when it comes to the Bagley-Keene Open Meeting Act. And the first is that people basically are allowed to attend meetings anonymously. You can't require that a person identify themselves or register in order to attend a meeting. Now, sometimes in this 9/11 world that we live in, we do have security requirements for admission into a building, and security personnel can get identifying information if they need it, but then that information is not to be passed along to the people conducting the meeting. If you have a registration or a sign-up sheet, then it needs to state clearly that signing up on that is not a requirement for attending the meeting, but instead it's a voluntary extra thing that people can do if they want to receive information or be put on a mailing list or something along those lines. But we would also suggest that the same policy would apply to testimony. The Act doesn't specifically say that, but if you can attend the meeting anonymously, we would think that you should also be able to testify anonymously, and if people don't want to give their names, then you can take that into account in assessing their testimony. People who come to public meetings are allowed to record them, and the only exception to that is if the recording would itself constitute a persistent disruption of the meeting. Otherwise, people are free to either photograph or have video recordings, audio recordings, whatever. When people testify, the requirements are that they be able to testify either before or during the consideration of agenda items. Our recommendation would be that you set the context of the item and then allow the public to testify on it, and then allow the members to deliberate on it. You're also permitted, but not required, to allow people to testify on anything under your jurisdiction, even if it's not on the agenda. The limitation there is that you can't delve into it and resolve it at that time. You're going to have to come back to a meeting or give direction to a staff member to deal with it or whatever, but the Act itself expressly permits agencies to accept testimony on non-agenda items. And we think the best practice there, which I think most state agencies follow, is to go ahead and put a public comment agenda item on your agenda where people can specifically be invited to come forward and talk about anything that's under the body's jurisdiction if they have something they want to testify about. You can place reasonable limitations on testimony if that is necessary. There are situations where there are hundreds of people that may show up to testify on an item, and so the bodies can take reasonable steps to limit the amount of testimony at that point, try to get people to pick a spokesperson, give that person more time to represent the group, and things like that. But you're able to place some limitations on in order to be able to actually manage your meeting. Acquiring records is another part of public access. When the majority of a body receives records, then the public is entitled to those records promptly upon request. So it's not a requirement that when you give records to a majority of the members of the body that you immediately have to send it out to everybody, but you have to make it available upon request. Items that are to be considered at a meeting that have been provided need to also be available at the meeting, and information that's provided to you by third persons at a meeting needs to be made available as quickly as possible. Internet posting, the law only requires that you post your agenda. Again, I think best practices say post everything that you can in connection with a meeting. It just is the most efficient way to get information out there and provides the most public access. The Public Records Act, along with its exemptions, also applies to the records of a body with one exception. The balancing test in Section 6255 is not available to multi-member bodies. It may be available to the staff, but it's not available to the body itself. And if staff seeks to use the balancing test, and it's an agency under the governor's executive wing, then the policy is that you need to seek permission from the governor's legal affairs secretary before you can assert the balancing test as an exemption to a request for records. Julia, I think you have some more.
I'm just going to briefly talk about closed sessions. As a general rule, all items placed on an agenda must be addressed in open session. However, the legislature has permitted exceptions to the general rule in limited circumstances, recognizing there are other countervailing considerations, such as the protection of an individual's right to privacy and the right of a board to receive confidential legal advice during litigation. Courts have narrowly construed these closed session exceptions. In order for a board to meet in closed session, the closed session must be specifically authorized by one of the provisions in the Act. There are various narrow exceptions that are very specific to state agencies, but there are two exceptions that might affect the board. The first exception is the personnel exception. Under this exception, the hiring, performance evaluation, disciplining, or termination of an employee may be discussed in closed session. The employee must receive 24 hours notice and has the right to insist that the matter be heard publicly. The second exception is the pending litigation exception. The board may meet in closed session to confer with legal counsel regarding pending litigation when discussion in open session would compromise the position of the board in the litigation. Litigation is pending when the board is party to the litigation, or the board determines that based on the surrounding facts and circumstances and the advice of legal counsel that there is significant exposure to litigation. Litigation is also pending when the board is deciding whether to initiate litigation. For the litigation exception to apply, the board's legal counsel must submit a memorandum to the board before the closed session, if possible, but no later than 1 week after the closed session. This memorandum is confidential until the litigation has been finally adjudicated. A closed session must exclude all persons whose participation is not essential to the matter. There are specific procedural requirements when holding a closed session. The general nature of the subject matter of the closed session must be placed on the agenda. The board must first convene in open session and disclose the general nature of the topic of the closed session. The board may only consider the matters publicly disclosed on the agenda. After the closed session, the board must reconvene in open session prior to adjournment. And that's
okay. So those are the things that we picked out as the highlights of the Bagley-Keene Act that we thought that it would make sense to describe to you. If you have any basic questions, we'll be happy to try to answer them.
Let me start off with a couple of questions. The first question I have is the staff exemption that you talked about. So under Bagley-Keene, staff, for purposes of briefing for this hearing, it's okay for 6 or 7 staff people to be in a room and be briefed, as long as when those staff members brief their individual members is on a one-on-one basis. Or did I misunderstand what you said?
Let me make sure I understand. When the briefings occur, it doesn't necessarily matter how many staff members there are there. The question is how many members of the body are there.
There are no members of the body, but I have staff, and the legislative members have staff, and Ms. Moore has staff, and Mr. Almanza has staff that report to him. And can we send our individual staff people to a meeting with the state allocation, with the OPSC staff, so they can be briefed on what is being discussed and the agenda items? A lot of technical stuff. There's a lot of history that went on some of these issues and some precedent-setting cases that came before us. And so our staff can go and ask questions about, and what did we do, and who changed the law back then, and clarifying issues that may not be covered in the written material presented by OPSC staff. Is your staff exemption that you talked about in Bagley-Keene, is that covered? Can we send all our staff at once to be briefed?
And when you say staff, you're talking about representatives of the various members?
Correct. So legislative staff, the assembly member has a staff, the senator has a staff, I have staff, and they go and get a presentation from OPSC staff so that we all make sure they understand what the issues are and what the nuances are on the individual appeal or an action case. And then they can then individually brief us. So my staff will brief me. Mr. Almanzo's staff will brief him. Senator Lowenthal's staff will brief him. That one-on-one is the exemption, or does the exemption for staff also cover the representative staff's briefing?
Well, I guess my concern there is that what you have there is more of a meeting by intermediary. In other words, one thing is that you can't, when we talk about serial communications, they can be directly or they can be also through intermediaries. So if we have a 5-member board, we know that members A, B, and C can't get together and talk business in an unnoticed meeting. Similarly, you can't have the representative for A, B, and C sit down and have a meeting as representatives of the members A, B, and C. That would be by doing a meeting through intermediaries. So my concern in the situation that you describe is that the staff briefing, which is supposed to be, and again, I don't know the full organizational context of this particular board, but if we had a staff for the board, the way that this would be envisioned is that staff could brief member A, and they could brief member B, and they could brief member C.
So that's
separate conversations.
So that's your staff exemption when, for purposes of board staff, Mr. Savage and Ms. Silverman, Mr. Juan Morales, who staff the entire board, they can meet individually with board members and brief them. That's the exemption you're talking about.
Correct.
But if Ms. Moore has a staff person that counsels her on state allocation board issues, and I have a staff person that counsels me on allocation board issues, and Senator Lowenthal has a staff person that counsels him on, and so forth. If it were a 5-member board, those 3 staff could not get together to discuss state allocation board issues.
For an upcoming meeting,
yes,
with the agenda. I would think that's the case, yes.
Okay. Mr. Hagman.
I mean, some of these things, our staffs, if they get briefed, and most of the time it gets briefed one-on-one, they are getting that information. They don't make any authority, they don't make conclusions, they don't make any votes on this panel. But they are gathering information on behalf of the members so they can be informed before they come up on this board. Right. I think the way it was worded is they're getting together to discuss state allocation board business. What they are is getting basically a debrief of what's coming up in their agenda so they could give us a brief. And I think that's a small but slight difference. I just wanted to get the interpretation of the Attorney General for that as well.
So that's sort of what I wanted to get to, so that there are a lot of these issues have nuances to it. And so board, OPSC staff briefs members and they brief staff. And when they brief members, they do it on a one-on-one level. And when they meet, when they brief staff, not for purpose of discussing the item, but just to say, here is the case. There's not question and answer, but here is the case. Is that acceptable? Can that be covered on the exemption of staff?
The fact that it's just information that's being presented doesn't take it out from under coverage. We have a published Attorney General opinion from some time ago that's been relied upon over the years that talked about a situation where we had a planning commission and we had a developer come in and brief members A and B, and then all they did is receive information. They didn't ask any questions. They didn't have any conversation. They just listened to the briefing. Then B left and C came in, and we did the same briefing again. Then C left and D came in. We did the same thing again. And the question was, is the receipt and provision of information without discussion and questions, was that covered? And the answer was yes. So the fact that we say, well, it's just information is not enough to take it out from under the coverage.
Ms. Moore.
So can I ask the question in a different way then? We're a 10-member board. 6 members constitute a quorum. So are you saying that 5 members of staff or 5 members of the board could receive a briefing at the same time?
Under the staff briefing, no, because they're not separate conversations, one member at a time. Under the less than a quorum, you could get 5 together that could be briefed or could even have a conversation because it's less than a quorum. Our concern at that point is, whether you can then brief the remainder of the members. It seems to us that the way the legislation is worded, that you have a choice, at least for staff, if they're going to be participating. They can either participate in the less than a quorum gathering, or they can do the separate briefings. Doesn't appear to us that you can necessarily do both.
Maybe I misspoke. Those meetings, they're hypothetical, but
Sure.
Let's talk with the staff meeting. So how many staff members of this board could receive a briefing at the same time and remain within Bagley-Keene?
Well, when we say how many staff members can receive the briefing,
Representatives of the board members.
right? Okay, so when we say representing the board members,
we have a staff that is staff to the board, and then each member has staff members that help with the issues. So I'm referring to my staff member, Mr. Reyes' staff member, Ms. Lowenthal's staff member. Institutionally, those staff members have received briefings at times. And I'm asking how many of them could be present at a briefing to receive it from the staff to the board and be within Bagley-Keene?
Well, certainly the safest answer is to follow the staff briefing exception, which would mean briefing one member's representatives at a time. Okay. So if we have member A, then staff could brief all of member A's representatives at one time, and they could also brief member A and his or her representatives at one time. My concern is when you're briefing representatives of members A, B, and C at the same time, when we consider those to be representatives of the member, then it doesn't fit under the staff briefing language, which talks about separate conversations with the member so long as there's no cross-pollination. You're not having separate conversations at that point. You're having, a group conversation.
Ms. Brownlee.
So just to clarify then, what you said is that 5 board members could sit in the room and be briefed on a subject.
But only 5. So you couldn't brief the other 5 at all.
I understand. But you're saying individual staff members of those 5 members can't be grouped together. Not more than 5 staff members can't be grouped together. The members can't. The members can. Staff can't.
No, I don't think that's quite what I'm saying. We've got 2 different theories here. The one is the less than a quorum theory, and the other is the staff briefing exception. So the less than a quorum theory says that if we have a series of communications that involves less than a quorum of the body, we have not had an illegal meeting.
Right.
Okay? So that's how we can say we can put 5 members or 5 members staffs, doesn't matter, in a room and have a conversation and not violate the law. Because
then we can do that, albeit I understand then under those circumstances the whole board can't be briefed.
You can have 1 through 5 in the room together, and that won't violate the law because 6 through 10 are not there and are never there. And 1 through 5 don't communicate with 6 through 10. Okay, does that make sense?
Yes, it does.
Okay,
Thank you.
so that's under the less than a quorum theory, but under the staff briefing exception, that one basically was a way of saying, even though the old rule was that you could never involve less than a quorum, under the staff briefing, we're going to let you involve not only a quorum, we're going to let you involve everybody, but it's under a specific set of rules. Those rules being separate conversations and no cross-pollination. So you got one approach or the other, and our thought is that you don't get to do both. We'll take less than a quorum to give us the first 5, and then we'll go separate communications with the next 5. So
it just seems like we're in the gray area of the law when you say that, because, I mean, staff could come from all members, be briefed all together, ask some clarifying questions, never have a conversation with each other, the staff, and then come back and individually brief each one of us.
Well, certainly that works okay if we're just dealing with member A's staff, then member B and member C. But let me tell you where the concern, I think, is. We have the staff for let's. Okay, sure.
Let's change the nomenclature.
Okay.
For our member staff, let's call them intermediaries for now. And then the staff is the OPSC. That way we're clear, because we keep talking about staff, and it could be OPSC staff or it could be our individual staff.
Okay.
So let's refer to the board member staff as our intermediaries, which is what they are.
Right.
And then OPSC staff is the staff.
Okay.
We refer to staff briefing members as OPSC staff. When staff is briefing intermediaries, that's our staff. So, I'm sorry.
Yeah, that's a good clarification.
Right.
I want to see if I can summarize it in a way that I understand it. So what, in essence, you're saying is that if you brief 5 members of the board, you can't brief the other 5 because then you have the equivalent of a serial board meeting. And those 5 that you brief, whether you're briefing them individually or as a group, that's the most you can have. The staff exception is that you can brief people 1 at a time, okay? Because then you don't have members asking questions, influencing other members before you're actually deliberating at the public board meeting. So I guess my question would be, if staff is briefed first, or excuse me, our intermediaries are briefed first, then the staff would have to brief each one individually if they're going to ask questions, right? And then you would have to, they either would have to, or you'd have to brief the board members a second time individually, which would mean LPSC staff would have to have potentially 10 meetings.
11, right?
Well, aren't there 10 of us, right?
Over 10.
So the option is to not brief everybody or to just use the staff exception and brief them 1 at a time so that the questions I ask don't influence the other members before we've actually come to deliberate in public. Is that?
I think that's a correct summary.
No,
Lisa.
so-
Do you agree, Julia?
Right. And that's why we think it would apply to intermediaries, because intermediaries could also ask questions that could influence
Staff, because
other
intermediaries are representatives of the board members. And the reason you can't brief all the intermediaries, even if you don't allow them to ask questions, I assume would be because you don't want to have the perception of the potential that they're going to ask questions. I mean, there's got to be that assurance with the public. Is that?
Well, I think it's that as intermediaries, they're just like the members.
Right.
So just like we can't brief all 10 members together,
Right.
we
You
can't
can't.
brief all
Okay.
10 intermediaries together either.
So back to Mr. Hagen's point, though, I mean, our intermediaries have a little bit more time than we do.
Right.
Our intermediaries have a little bit more time than we do, so they can kind of go deeper on some of these issues. And if the presentation was one way and no questions were asked by intermediaries, you still have a Bagley-Keene issue?
Yes, I think so.
Okay.
The fact that it's one-way presentation of information and the other side doesn't ask questions doesn't exempt it from the coverage.
Okay. Any other questions on staff?
This is probably not an approach you want to follow, but I understand your dilemma and I appreciate the difficulty of the situation. One other way to possibly deal with it is to do the briefings as notice meetings.
Okay. Next question.
And then if you notice them, then you're going to have the public potentially can ask questions before you've even had the formal board meeting, right?
Yeah, this is long meetings.
The public have access to it, right? Well, no, it wouldn't have to be 10 long meetings. If you notice there's a meeting, you can do it all at once.
It was pre-hearing for the meeting, for the hearing.
That's correct.
Yeah, okay. Second question I have is, this school construction is a very of interest to a lot of folks. So suppose the Senate and the Assembly decide to have a joint hearing on how to move forward on school construction. And the folks who are sitting on the board right now, we have six assembly members, 3 assembly members and 3 senators. And clearly they have a very vested interest on this. So they call up a hearing. And as part of that discussion, they would like to have somebody from the Department of Finance to come and talk about the money associated with school construction. Do we then have a violation that we have 7 board members at a hearing, or is it the fact that it's a public hearing and it's a legislative hearing, we're off the hook on that?
You should be off the hook on that.
Okay, excellent. That was my other questions. Anybody else have any other questions? Great. Well, thank you. You can see that we have a lot of questions. We had a lot of questions on this. I think it's been very enlightening. Not quite what we expected.
Sorry about that.
It's all right. The law is a law, so we will now move forward with full knowledge. So I appreciate your time. Thank you very much. Appreciate it, Ted, Julie. Thank you very much.
Thanks.
Take care. Happy holidays.
Thank you. Thank you.
Sorry. We'll publish
Yeah.
it online.
Ms. Moore?
There's one other wrinkle that we have on this board that's unusual, and that is that the staff to the board also has a board member on the board. Is there any concerns in that? Is there any special consideration that must be given in that situation?
So for purposes of establishing the quorum of intermediaries, the Director of General Services is a member of the board, and the Office of Public School Construction is within the Department of General Services. So the question is, and they're the folks who are the staff to the board as well. So the question is, when you have somebody from OPSC making a presentation, you already have one intermediary in the room. And can you have 3 more or 5, can, you know what I'm saying? What point does that count towards establishing the quorum issue? Ms. Moore, is that your question?
Yeah, I mean, that's the unusual component. Well, this board is unusual in many manners, but that it has a board member that comes from the agency from which the staff is a part of. So is there any wrinkle in that around the staff then? And I'm not talking about intermediaries now. I'm talking about staff to the board as they give their briefing now. As I assume we would have a one-to-one briefing with every board member. Is there any thing we need to know concerning that?
Well, can I follow up? I guess I would think that all the staff members for OPSC would have all the same obligations with respect to every board member, unless there's one that's specifically assigned to just the one board member. Would they all be Well, I'm wondering if they are really an intermediary. Are they assigned to just that one board member, or do they have obligations to every board member?
Well, I think the problem, Julie, is that the staff are the employees of a board member.
That's correct.
And so in one sense, not only are they the staff to the entire board, but they are also, in some sense, the intermediaries of that board member by whom they're employed. And that's the dilemma you're asking about,
Correct.
right?
So I guess that was the follow-up question I was trying to. Okay, so there's some level of control that you have over the staff that other board members wouldn't have.
That's true. He likes it that way.
I guess we could discuss that further, and maybe this is a question we'd have to get back to you.
Okay.
Yeah.
Thank you.
Why don't we do that?
Thank you very much. Appreciate it.
Thanks.
Good question. No, that's a great question. Thank you. Very good question. Thank you. Okay.
No, it was 12. Let's jump to 12.
Where are we, Ms.
Well, we'll skip the financial report and
Yes.
do that at the end. Go to 12 for labor compliance.
Labor compliance, okay. Thank you. Yeah, I don't want them up. Can we very quickly lift the roll call on the minutes and item 11, please? Real quick.
Senator Lowenthal, minutes? Okay. Tab 5, consent?
And that
Okay.
includes all the other consent items that were added on.
13, 15, 16, 18, 11? No.
I think 17.
They accepted.
17. 17, we still have not gotten to that. Okay. Okay. So is that a nicer? Okay.
Great.
And on all the others as well. Okay.
Okay, great.
All
Thank
right.
you.
And then 11?
And 11. Okay, that's great.
Thank you.
Thank you.
Okay. Please, keep us in track.
Brian O'Dell, Office of Public School Construction. I'm here to present the item found on tab 12 in the agenda, prevailing wage monitoring proposed regulations. Also begins on page 621. Just as a background, AB 1506 in 2002 was signed into law. It required SFP projects funded from Propositions 47 and 55 to have a labor compliance program. It could either be administered directly by the district or a third-party vendor that was approved by the Department of Industrial Relations. In 2009, SB X29 was signed into law, and that extended then to all state bond-funded projects once it took effect. In September 30th of this year, AB 436 was signed into law that amended those provisions. It still applied to all state bond-funded projects. It required the Department of Industrial Relations to provide direct monitoring for state bond-funded projects once it took effect, which is January 1st, 2012, for all construction contracts awarded after that date. There are two exceptions. The projects would be subject to these provisions, but DIR wouldn't have to provide the monitoring if the district has a previously approved in-house labor compliance program, or if the project is subject to a collective bargaining agreement, or as was mentioned earlier, commonly referred to as a project labor agreement, with certain provisions that the statute contains. So the Department of Industrial Relations has regulations that were approved by the Office of Administrative Law. They take effect January 1st, and the process works where a district awards a construction contract, then sends a notification to the Department of Industrial Relations of the contract. The DIR then begins the monitoring services and sends an invoice to the district for these services in an amount not to exceed 0.25% of the total state bond-funded proceeds. So what these proposed regulations would do is, one, calculate a school facility program grant. That would be the state share of 0.25%. So if it's a 50-50 project, it would be half of that, or if it's a 60-40 split. If it's a 50-50 project, the state grant for every $1 million would be $1,250. That's the way it would work. The state share would also include any financial hardship program funds, any loans that were provided through the Career Tech or the charter programs. All of that would be lumped together, and then the calculation gets run. The funding applications, there's a total of 6 of them for some of the different types of programs, are also revised to determine whether there are construction contracts for this project that were awarded on or after January 1st, 2012. And it also requires districts to indicate whether the monitoring services will be provided by DIR or of the other two options. It also asks districts that if maybe it's a reimbursement project in April or May of this year, the construction contract maybe was signed in 2011, would they be able to comply with the AB 1506 provisions? In other words, would they be eligible for Prop 47 or 55? That's something that we'd be able to determine moving forward. The fund release form, 5005, would be amended to require districts to submit notification from DIR or from DIR that they've been notified, confirmation that they've been notified of the construction contract. For the first 6 months until July 1st, 2012, because the new process could be kinks in the system, districts would have the option of just providing a copy of the notice that they sent to DIR. That would just be until July 1st, 2012. And that's the presentation. Are there any questions?
Thank you, Mr. Chair.
You spent a lot of time with folks on this.
Yes, sir. Excuse me. We met with the Implementation Committee of the State Allocation Board on 2 occasions. We invited the Department of Industrial Relations to the meetings. They were in the bullpen, if you will, answering questions, getting feedback from the school districts that were in attendance. We had a really good process of working with them to try and come up with a system that we hope will end a lot of the confusion that there may have been regarding compliance with the labor compliance programs. And going forward, we think that the procedures that we've set up that we have or are bringing to you today will really make it easy to comply and simple. For example, we talked about a variety of procedures or options that we looked at, including a direct deposit option with DIR. But the regulations we're bringing you today propose that the funding would go to the school districts, as the school districts are the awarding bodies, and they have legal requirements and responsibilities under the statute and under the law and public contract code. So the districts will make payments directly to DIR after they receive their funds from the state. I think a lot of the concerns that we're hearing from the field have to do really with the transition period where the statute will go into effect on January 1st. Our our regulations may not be approved if the board adopts these today. Our regulations may not be approved by the effective date of the Labor Code statute, of the DIR regulations. And so what we're doing, though, is we're informing school districts that if you execute a contract after January 1st, 2012, and you are intent on receiving state bond funds, you must register this project to be safe, to be that you will be in compliance at the time you will receive the funds. And so I think once we get over the hump of this transition period, and I think couple of the public speakers talked about, how we look ahead 3 to 6 months, we believe that this will be a simpler, easier procedure for districts to comply with. One of the other speakers that had brought forward a concern about labor compliance programs, district labor compliance programs, and project labor agreements. DIR has indicated to us that they will not be approving any further, under their current ruling from their director, any more in-house labor compliance programs after January 1st. However, there's nothing in the law and nothing in their regulations that makes any representation regarding project labor agreements after the effective date of the statute. So as we go forward, there's a subset of districts throughout California, around 50, that have existing previously approved labor compliance programs that would be an option for districts to use under this law. So going forward, we see this as eventually simpler and less confusing for districts to use the compliance monitoring unit of DIR, and we appreciate your support in taking these forward.
Okay. Ms. Buchanan, Mr. Hagman?
Couple questions, because I had noted in response to Jeremy's question regarding the wording, whether it was technically accurate or not. When we talk about having, in your summary here description, you talk about having a qualifying collective bargaining agreement, and we don't refer to a PLA. A PLA may or may not be a collective bargaining agreement, right?
It generally is.
It generally is, but it may not be. So what does the actual law say on that? What terms does it use?
It uses collective bargaining agreement that binds the contractors. Do you want to read it directly, Juan?
Yeah, and that's why we stuck with the language, just so we remember. We didn't make references to the project labor agreement in the regulations because we stuck to the language that's actually in statute.
And so AB 436, what does it say then? I meant to.
But it's entered into collective bargaining agreement. Actually, get to the actual
I don't think it wasn't. 436 wasn't in the attachments. I was at a conference, so I didn't end up pulling it up and reading it.
AB 436 amended Labor Code Section 1771.3 B3 says the contract is awarded on or after the effective date of the regulations described in paragraph 1 if the awarding body has entered into a collective bargaining agreement that binds all of the contractors performing work on the project, and that includes a mechanism for prevailing wage disputes.
Okay, it just.
Part of our process related to this at the M committee was we recommend to school districts that they seek legal counsel if they have a PLA in place to confirm that it meets those requirements. We did have a legal opinion from a practitioner that was provided to the M committee that gave us the background and history of collective bargaining agreements in the construction industry that pre-bind contractors to that process, and then also contain mechanisms for dispute resolution regarding wages.
Okay. And then there was another question asked by about this does if I pass a bond in 2014 and enter into a PLA agreement at that point in time, that still will allow me to be exempt from that 0.25%. Correct? It doesn't have to be in place earlier than that. And then my other question was the 0.25%. Does that apply to I know the state fund is half of that. But say you've got a modernization project and the state funding is providing really 30% of the total contract cost, because the modernization, it's not uncommon for it to provide less than the 50%. The 1/4% applies to the whole contracted amount, or does it apply to the state portion, assuming that's 50%? How is that calculated, and is that clear?
It's based on the state bond proceeds. That's how you get to the 1/4%. And then depending on the program, there's the applicable local match apply, whether it's 50-50 or 60-40.
So if I had a modernization project that was $10 million and the state was going to only provide $2 million, then the labor compliance costs would be based on the $2 million, or theoretically $4 million, and not based on the remaining amount.
That's correct.
So we're not collecting much for labor compliance in that situation. Okay, those are all my questions. Thank you.
Thank you. And for the bonds we're going out, first of all, we have different bond funds. This is, I guess for the record, I didn't support this when it came to the legislature, this tighter regulations on what we're doing. But this is the tightest we've had on these bond funds so far to date. Previous bond issuance didn't have quite those things. That's why we had the two examples. We had to sit there and switch funding sources in the past. Now, the hundreds or perhaps thousands of projects that we have funded so far, 2 is not a high number of going astray as far as not watching the rules, but we had 2 so far this year. First of all, for those projects that are funded under the Bond Act that would not require this type of language, my question is more of a legal one. How do we go back for a voter initiative and change the parameters that the voters voted in? Is that retrospect? I can say going forward for new monies and stuff, but this is enacted years ago when this was not a requirement. Can we legally do that without going back to the voters? I guess that's the first question.
I believe that was done in statute. Is that correct, Lance?
If I understand your question, the new statute, the bill enacted, changed how we were going to fund labor compliance and also changed who would be enforcing it. And it put a demarcation point, contracts that would be awarded after the regulations were in place after January 1.
But I understand the premise there. But again, if we're going to be looking at the different things when we run out of money, these different pots of money, and when that is legal to move it for another source together, or can we combine them, those type of things. I understand that other provisions that the voters have passed in the past, we can only do so much as a legislature to change those rules, so to speak, of how it works, because unless we hit the 2/3 threshold and start overwriting that, I guess it's the bigger picture. Can this affect those? I understand what the bill was passed and signed into law. I understand what that states, but it doesn't say particularly what things. It says going forward in the contracts. This is a funding source that was done prior to that in some cases, many times without those different rules. Does that change that structure, that bond fund enough to where we have potential litigation coming down the line in the future over that? And I understand that the SAB board can write their own rules and regs as far as what we want to see, but can we counteract the voters in that way? And that's more of a legal question than that.
The opinion of the Bond Counsel at the Attorney General's office is that the enforcement of the prevailing wage laws is a cost of construction, and that's the way they worded that way into the new laws that were enacted. That is a cost of construction. So what this does is narrow it down what the Department of Industrial Relations can charge, and it puts down a specific figure, and it authorizes us to be able to increase our grants because it's part of the construction cost that the school districts will be incurring. So under that, we're not changing the prior will of the voters. And of course, the original AB 1504, the original one, that was enacted. It wasn't actually part of the Bond Act. Of course, it was only enacted if those Bond Acts were enacted.
And I understand, and I'm not having a problem with the prevailing wage aspect. I'm having the problem with saying we're going to spend with the state matching funds, 1/4%, 1% or whatever, on $1 billion. That's considerable amount of money going out for something that the voters didn't think they were going to be paying for. Basically, an agency within the state government to basically take another chunk off of it versus going to building. And how much can you figure out? What, 1.3 billion? It's 130 million of at 1%, so roughly $30 million in fees going off on just this issuance alone to DIR. That's several projects that we could have funded if that fund was not being diverted to a state agency. That's why I'm wondering, can we legally do that with, because we didn't go to the voters and say we want a percentage of this to go to basically mandate a state agency to cover it. Understand the prevailing wage laws, they were there, and I support that part of it. I'm wondering, can we mandate this going off of those costs? That's the legal question. So if we have a written opinion from the Attorney General for that specific, I'd love to see that and see if they cover that part of it in the future. But I just have questions on that because I don't think that was part of what some of the voters voted in back when they asked for the Bond Act. Because when you grow it, that's just our one issuance here. If you grow it over a $10 billion bond, that gets considerable. $300 million.
DIR represented to us during the meetings that this level of funding would actually be considerably lower than the funding amounts under Proposition 47 and 55, and more cost-effective and efficient, and the dollar values will be less.
I was going to say, if you go to page 631 and you take a look what the amounts are now for compliance, we're actually going to be spending less money on compliance.
Even with the in-house people they have?
Because the total is 1/4%. It's higher than that all the way through.
I know. No problem. Thanks. That's all my questions, Mr. Chair.
Okay. Mr. Savage, you have the look of, I want to say something. No? Okay. So we have Lyle.
Thank you, sir. Lyle Smoot, representing Los Angeles Unified School District. And I want to start right off by saying we are ever so happy to see the implementation committee up and running again, and we believe that they did a stellar job on addressing this issue. It was a difficult issue. They really took the time to go through it, and we're very happy with the total product. We do have some concerns still, little concerns about documentation submittal and documentation timing, but after hearing my colleagues ask this board to have an automatic review hopefully through the implementation committee in 3 months, I think that would be a good way to address any remaining issues we have, especially after having an opportunity to go through the process and see if it works. Our biggest concern, however, is that this regulation will be applied and utilized on January 1st. Districts will be subject to it. However, it will not be effective at that point in time, and I'm not sure exactly how all of that works. And my concern is twofold. One is that we're applying a regulation before it's in effect, but two is that you have had, as a board, some confusion about the labor compliance requirements of the program, and so to have a situation where you don't have an effective regulation and districts are going to be subject to it, I think creates an opportunity for confusion. And I think along those lines, I would just ask that you have, that information in hand so that anybody does have a problem with it, you'll already know that may have been created by the fact that your regulations weren't in effect at the time of their submittal of their applications. Thank you.
Thank you.
Appreciate it.
Ms. Buchanan.
Is there, when you read on this, on your report, it talks about has to be, you talk about the has to be in effect implemented when the OLA, it requirements of when it's going to be implemented. Is there anything in the bill that would restrict us from implementing it before the approvals there? Is there anything that, because you say it are in effect, the Department of Finance has approved the DIR's fee, so our word after that. I mean, is there anything is there anything in the bill that restricts us from adopting a month early?
You're referring to DIR's regulations, some of them, or
Well, it says, the DIR's monitoring services will be provided in compliance. These services will apply to the projects with a construction contract awarded after both the DIR regulations are in effect and the Department of Finance has approved the DIR's fee structure. So if we make put that in effect January 1 and they haven't completed that till February 1, is there anything that restricts us from having ours become effective before? I mean, is there?
Their regulations have been approved already, so
we're fine.
Yeah,
So they're ready to go. So we're the ones that now need to play catch up.
We're just a little behind, and we're trying to catch up by filing them on an emergency basis.
Okay.
All right.
Okay, I'd like to move on the staff recommendation to approve.
So moved and second. Are there additional comments or questions? Hearing none. Call the roll, please.
Lowenthal?
Aye.
Brownlee?
Aye.
Buchanan?
Aye.
Hagman? Almanza?
Aye.
Moore?
Aye.
Rays?
Aye.
Motion carries.
Thank you. Ms. Moore.
After the vote, I'd just like to, if the board is agreeable, I think we heard from a couple of constituents that they'd like a review of this within a certain period of time. I do think it is a new requirement. It is quite different for school districts, and I think it would be important to review it. If the board agrees, first perhaps with the implementation committee in 3 months, and then come forward to the board. So that we keep it in the forefront for school districts that this is the new way that you must comply with the labor compliance component, and to tease out any problems early on so that we don't have appeals or other issues come before us later.
Is 3 months too soon, though?
I would recommend a little bit longer.
Yeah, I was just going to ask, what are they reviewing in 3 months?
Yeah.
Because they've signed a form, but you haven't completed a project or haven't been audited. So what specifically do you
What I like to see is just more education to school districts, particularly those that are going out there. Just get the word out, whatever vehicle you have available to get the communication to folks, because that's really the piece. And yes, Lyle raises an issue, a legitimate issue that we're holding folks to a future regulations is not in place yet. So, but those are going to be the rules of the game, so you might as well play by those rules because you'll be impacted by that. And
I guess I would just respond that it has been an issue of great confusion before this board for over 2 years, and that.
But that was before Bill.
That is correct. So we'll put it back into his good hands. I just think that to have a review once this program has had its opportunity to begin, and we have 2 different agencies involved. We have our staff involved, and we have the DIR staff involved. And it's going to have a transition period. And I just think it would be important to come back before us and ensure that it's operating correctly.
I don't have a problem. I just want to know what they're reviewing, because I submit a project that's going to start after January 1, and by the time you get the contractor gets the bonds in place and everything else, I don't know what. I mean, you may not even have any shovels in the ground for a couple of months. So what? I just want to clarify.
I don't know what the actual problems might be, and that's what I'm asking about. I don't know. I'll tell you from being in the field, when new things occur, a lot of stuff bubbles up from that. And if there's anything that bubbles up that we as a board should be aware of, or that the staff should be aware of, I certainly want the opportunity for the field to be able to provide that input and for us to hear that. And I think it would be beneficial. And as I said before, I'd rather take care of issues in the next 6 months than to hear appeals 3 years from now.
So why don't we go this route? As you point out, this is going to be an implementation issue. Things are going to be coming up. Bill, you have the implementation committee going on right now. Folks can use that as a vehicle. And once you report back to us in terms of what you're hearing, say in 6 months, and at that time you can then tell us, this thing requires clarification. This is the stuff that is causing heartburn for folks or whatever. It may be causing heartburn, but it may be the law, and we may not be in a position to change anything, but at least we will know what it is, and we have legislators on the dais who may want to consider going back and clarifying the law. But at least that way, you will have the pulse of the constituent groups that are impacted by this. Is that a reasonable approach, members? Yeah. Okay. Sir.
Mr. Chairman, members, Tom Duffy for Cash. I appreciate the discussion about this, and just two things. One is, because of the importance of it, we're having a series of workshops on this in January. We'll have one here in Sacramento and one in Southern California, and we're inviting all parties that have been involved in it to be able to present and discuss the implementation and make sure everything is on target. The second thing is that we do appreciate very much, Mr. Chairman, your comments about having the implementation committee as a forum to be able to bring issues. And we will do that. But I think, and I don't know if this was in your mind, Ms. Moore, but when we were implementing AB 1506, the implementation was something that caused a number of reviews, and they were reviews that were done in front of the allocation board. And it was very helpful to make sure that we resolved issues, because there are two agencies, not simply OPSC, that's involved. And we do not have any connection with any oversight body, such as the allocation board, with the Department of Industrial Relations. So it was a good place to be able to say, these are issues we're trying to resolve. And with the influence of members of the legislature as well as the administration, it was very helpful. So we will indeed work with Mr. Savage and the implementation committee, but just wanting to bring that back to you, because it was a very effective vehicle to implement and to resolve issues with AB 1506. And this has been a rather complicated and confusing issue, but thank you very much.
Okay. I think DIR has been a very close partner on this, so to their credit, they've been very flexible and willing to work with us in moving forward. Ms. Silverman.
Yes, staff is actually trying to work with DIR to try to have some outreach functions, so that way we could kind of give folks the education piece on how to be successful. So.
Excellent. Okay. Thank you. Next item.
14.
Mr. Chairman, that was, I pulled that earlier,
yes.
And my questions were answered, and I would like to move.
It's been moved. Is there a second? It's been second. Item 14, charter school facilities, moved in second. Without objection, it will be unanimous of those board members present. Thank you. 15 was consent. 16, consent. 17, and I'm sorry Ms. Brownlee left, because I really wanted to thank her for her request for Ledge Council. We like to have the Ledge Council opinion put into the record, so that should be part of a guiding principle moving forward. I would like to thank Ledge Council for clarifying this issue and request that the board include the Legislative Council opinion in its action today. I think it's important to encourage school districts to keep energy efficiency in mind, especially when constructing new school facilities. Legislative Council review provided clear legal authority for school districts to apply for energy efficiency incentive funds, which provide school districts with funding to incorporate energy efficient designs and materials when constructing facilities through the Overcrowded Relief Grant Program. Legislative Council's opinion correctly identifies construction undertaken through the Overcrowded Relief Grant Program as building new permanent school facilities, and thankfully with Ledge Council's staff clarity, these new facilities are more likely to incorporate energy efficient designs and materials. I'd like to go that on record too, because I think I'm grateful that folks asked for this. Sophia was very instrumental in getting that and pushing council to get the information. I know this delayed, LA delayed this decision for a while, but thank you for your patience. It's been moved. Second.
And I want to thank you for introducing that into the record.
Thank you. Okay, it's been moved and second without objection. Unanimous of all those present. Thank you.
Tab 20.
18?
20.
20. Thank you. Besides immigration.
You have DSA. No.
Thank you.
Hi.
So staff wanted to give the board somewhat of an update of what we're doing and the progress we're making in this program with related to the seismic mitigation program. As you all are aware, the regulations were changed and went into effect on September 8th, 2011. And we wanted to highlight, at least from staff's perspective, of what's been happening with some of the applications. We currently haven't received any additional funding applications. So unfortunately, we don't have any news in that area. But we wanted to remind the board that we did fund 3 projects in the past for $4.7 million. We still have $194.7 million available. And again, those folks should realize that the program did change significantly. And what we did wanted to highlight is we did receive a grant, $200,000 from the Seismic Safety Commission, and that $200,000 have slowly been depleting. We actually had a free evaluation template that was available. We had about $127,000 available for school districts to tap into that free template review. We've actually have exhausted that free template money. So those have been expended. That actually did go out for 5 additional school districts for 40 different sites. So we're happy that folks are moving forward with those template reviews, so hopefully they can move forward also with the Division of State Architect. With that, I think DSA is here to present their procedural updates.
Thank you. Welcome.
Great. Good afternoon, board members, chair. My name's Howard Ship-Smith, acting state architect for a bit here, and I have with me Masha Ledsick. And we could give you a brief overview of the process changes. These are contained in the document that you did receive as an attachment, and then a status update on the projects received under the...
In the interest of time, if you can give us the Reader's Digest version.
Yes,
we can do that. Level.
Right. So I think with our report, we tried to provide a abbreviated version, and just to highlight the on the second page of our report, a couple of things that are new process improvements for us for DSA, and give you an update. The first thing that we did very quickly is adopt a template for eligibility reviews. It's intended to make the applications and our review as consistent as possible, rather than accepting a free format structural engineer's report. This is a template that everyone's required to complete. And the template was developed with as part of the grant contract that was awarded with the grant money from the Seismic Safety Commission. And of course, with the expanded eligibility criteria, we had to incorporate the process and the guidelines for doing additional evaluations for geologic hazards that weren't previously eligible, such as liquefaction, faulting, and landslides. So that's also included on our revised procedure. And the additionally, when we set out to amend our procedures to incorporate new regulations, we also took an opportunity to streamline our process and give it a lot more structure, and we attempted to put our procedure in terms of phases to give the clients, DSA, OPSC, CGS, and everyone involved a clear understanding of how the applications would flow through the process. So we basically have 4 large phases of review, and the first phase is the evaluation of whether the building is eligible or not. And for that particular phase, we've received, as of the writing of the report that you have, we had 66 applications. Since 2 weeks had passed, we now have a total of 79 applications. Those resulted in 47 eligible buildings. We do an application per building, again, for streamlining and efficiency purposes. The rest of the applications are either under review, or they have been deemed incomplete and the clients are working on completing them, or the structural analysis that was done had errors, and that's a very minor amount, I think about 5 applications, and it went back to the preparers for corrections. So that's where we're at with...
Roughly how long does it take to get them back from the districts when you send them out for corrections?
I would say 2 to 3 weeks.
Okay.
But a lot of districts have... multiple applications, and if there's a problem with completeness, for example, it will typically impact multiple applications, so we kind of process these things in bundles.
Okay. How soon are we going to get money out? The real question.
It depends on the level of preparedness of our clients, I believe. Okay. And we have been getting questions from those that have actually already gone through DSA review with plans and specifications for either replacement or rehabilitation of buildings before these new regulations. Districts on their own doing this, but we haven't actually seen any applications. But those would be the fastest because they've already gone through the process. They simply have to do additional verification that they actually comply with and meet the requirements of regulations, but we haven't seen them yet.
Okay. Mr. Senator Lowenthal.
Yeah, I just need to understand. Have we heard any concerns from districts regarding the new procedures?
We have not. We have conducted a public meeting before releasing these. We've answered a lot of questions. We have received a lot of questions on how to comply in a particular circumstance with a particular building structure, but we haven't received any complaints.
So with the new regulations or the procedures, how many more applications, I did not follow that, have we received?
Today we received 79 applications.
And those 79 are, how many would before you change the procedures?
The 79 are the new ones.
Okay, so the 79.
Right. Before we changed the procedures, I want to say that we were somewhere in the neighborhood of 70 also. About 50 of those were completed by the districts on their own, and about 20 were done with the funds from the Seismic Safety Commission, around that.
So these are 79 additional
new ones, yes.
Right. And
purely under the new regulations.
And do we have any idea about approximately how much, if they were all funded and went out, how much money that would be?
We can't tell at this time. It's
Because
too
we don't have the full scope of the project.
Full scope.
Chances of funding 79 with $200 million.
I don't think so either. I just wondered how much.
Well,
so you're anticipating that we will get, though, the $199 million out now?
It will depend on which course of action the districts choose. If they choose rehabilitation or replacement, and how extensive that rehabilitation has to be. So it's a difference in terms of the board, terms that the board is used to. It's the difference between modernizing or replacing with new construction. So it will depend on what is the course that the district selects for that particular building that's been deemed eligible in this first phase of review.
So when would we, since the driving force behind this is to get that money out as quickly as possible, when will we have a picture of whether it's working or not?
I will only tell you, since the gym at the school district where I was on the board was the first one to qualify under this program. It takes time by the time you've got a structural engineer and a soils engineer and others to take a look at a school to say, yes, it can be occupied, no, it can't be occupied, and the fix is A or B. I mean, it's something that just doesn't happen in 3 months' time.
I'm just wondering about how long.
I would think it'd be the better part. Well, depending on where they are in the process, I would think it'd be the better part of a year. And that would be irrespective. But it just, like I said, it takes time to do that kind of work.
I got it. I just wanted to know when we would have a feel for how these new regulations.
I don't know, but that would be my guess. Maybe Bill would.
That's absolutely right.
Okay.
About a year.
Okay.
Yeah, that was one of the questions I raised to staff during the briefing. Now that I can do it in a public setting to Bagley Keene, that was the issue that I had. It was just one staff, OPSC staff, and myself.
Just checking.
Want to make sure that I was in compliance, but that was a question I had because this is an area that we were very interested in. We open, and so it's sort of frustrating that there's still. But I understand, Ms. Buchanan. There's a lot of legwork that has to happen
at the district. And the school district doesn't know what to do. I mean, it's sort of like we think we have a problem. One, do we really have a problem? Two, if we really have a problem, what's the remedy? How do we fix it?
Okay. Well, keep at it. We're very, very interested in getting the money out. There's clearly a need out there. And so thank you, and we expect to have another briefing from you.
Thank you.
Thank you very much. All right. Okay, so we have tab 7 on the funding. Is it okay with the board members to just bypass that? I mean, we have it as informational. It's not an action item. And I apologize. We sort of jumped because of quorum, and then also we had guests that we wanted to address or have them do the training. So take us to the next level.
Tab 21 is just our workload.
Okay. It's also informational, no action?
Very informational, no action, and we're going to be very loaded in appeals in January.
Okay. And then tab 22 is also a non-action item.
That's just the meetings.
Okay. Now I'll invite public comments to anything that has been discussed, and I apologize for not doing that every item. Board members, does it make sense to have the public comments at the end instead of the beginning? Today we had public comments and folks came and talked about issues that we're going to be discussing later, but it is a public comment, so they could come and talk about almost anything.
My suggestion would be that if the public is going to comment on specific agenda items, they comment in that agenda item.
Right.
And that since people travel great distances to be able to present their appeals or whatever, that at the end then we have public comment on anything that's not on the agenda.
Non-agenda items.
That, I know you guys have it in the agenda before my time to have it early on, and Mr. Walworth and I joked one time about what are you talking about, and it is in fact in our agenda for folks to come in. And today we had folks who don't come often and wanted to talk because they want to make sure that their point was taken, which was helpful. But it seems to me that as we move forward in each individual item, we should allow for public comment, and then at the end, we should allow for public comment for anything that's not in the agenda.
Right.
I have one caveat to that.
Yes, Ms. Moore.
And that would be that if someone has comment on something that is not in the agenda and our meeting runs long, that we allow them to, or we accommodate them because people do come from great distances sometimes. So at the chair's discretion.
If people make me aware of that, then we'll take that into consideration. The chair's interest, if you haven't noticed, is to move us out of here quickly. But, you know.
I had not noticed.
Yeah. So, anyhow.
I just have a final comment, too. I would really like to recognize staff on the $925 million that went out. I know that there was a tremendous amount of work that went on with that, and that is the most important work I think that we do now on a biannual basis, and I wanted to compliment them on their work.
We're talking OPS staff or intermediaries? Both. Mr. Hagman.
I was going to just do a follow-up, too. We talked about a number of potential subcommittees coming up for this working year as our bond funds run near, as we've kind of worked through some of our problems. This will get everything smoothed out. Of course, we're not money. So any thoughts about setting those up in the calendar for that as well?
We will put that on the list of things to do. Thank you very much. As the chair's prerogative, I want to wish everybody happy holidays. See you next year.
Thank you.